Hi, Honorable Matsamai. Morning.
Morning, Gashwin.
Are you well?
My life is progressive, my brother.
Good, excellent. Good to hear you. Enjoy the meeting.
Okay, thanks so much.
Good morning, Mr. Dixon. How are you?
Well, thanks, Mr. Dupree. Are you well?
Yes. Under circumstances, yes, perfect. Can we try to share my screen, please? And I would also like you to allow Miss Alison Botha privileges to share her documents.
Great, we'll do. I've made you a co-host, so you're able to just present now.
Oh, okay. Let's just quickly test it. Right. No, I think I'll have to go out and quickly. Oh, yeah. Sorry, I had to restart my computer. Let me just quickly go
Okay.
back open. Sorry about that.
No problem.
Okay, I'm ready for you. I'm just going to quickly check. And I presume you can see it.
Yes, that we can see. Could you just make it a bit bigger? Yeah, that's perfect. Thank you.
Thank you.
Good morning, honorable members. I take it it's still morning. Let me welcome you to this meeting. And just in terms of today, we're expecting a briefing by the Minister and the Department of Justice on its responses to the public written and oral hearing submissions on the Prevention and Combating of Hate Crimes and Hate Speech Bill, as is indicated on our agenda. Let me take this opportunity as well to welcome the Deputy Minister. I see he's on the platform, as well as the legal team from both the Department of Justice, as well as from Parliament Legal Services. Welcome to this meeting. Just in terms of members who are currently present, firstly, Gershwin, were there any apologies?
Good morning, Chairperson and members. No, Chairperson, no apologies.
Okay, thank you. Just in terms of members who are currently on the platform, we have Honorable Smith, Honorable Mikolakis, Honorable Maleka, Honorable Motsamai, Honorable Ndungini, Honorable Radebe, Honorable Badenhorst, and Honorable Dodovu. Once again, honorable members, welcome. Just in terms of where we are in relation to this bill, our members will note that we hosted public hearings on this bill on the 19th, 20, and 21st of September. We received 30 oral presentations that were made on the bill over the course of 3 days. And a few organizations made further submissions based on requests from the committee. The department will today provide their responses to both the written and oral submissions made to the committee. Members will have received the department's relevant documents in relation to the department's responses. I think there are quite a few documents that members have received. Just in terms of today's proceedings, we'll allow the department to present, and thereafter we'll allow members to engage with the department if there are further areas of clarity. Members should note that today we do have a limited time in today's meeting because we also have a plenary at 2, so we cannot stretch the meeting per se. But we will have more time in our next meeting to deliberate more in depth on the bill. Our members, I think that being said, let me then hand over to the department to take us through. Over to you, Deputy Minister.
Thanks, Chair, and good morning to you and good morning to the members. I'm joined by Mr. Henk de Peer and Ms. Alison Buerta from Legislative Development. Ms. Kale Pillay is currently in another meeting, which is the department's presentation to the Portfolio Committee on its annual report. So she may join us later if she is able to. You would have received a submission or a response to the submissions, oral and written, that were made. I don't know if you want us to go through those. Those are quite long. In addition, and Mr. de Peer and Ms. Buerta can speak more to those documents. There were additional support documents that were also submitted. What we had noticed was that we identified 7 key issues arising from the public hearings. Those were the issue of the existence of current remedies in law, which may result in the bill not being needed. Secondly, the provisions of hate speech in the Films and Publication Act. Thirdly, a proposal that the bill be split and only the hate crime sections be passed. Fourthly, that the bill is not in line with international conventions. Fifthly, that the definitions in the bill are I thought it was circuitous and ill-defined, and it doesn't define hate, harm, and hatred. 6, that the provisions of the bill are unconstitutional and not in line with Section 16 of the Constitution. And 7, a issue of the maximum sentence for hate speech is excessive. So, Chair, I don't know if you want Mr. du Preez or Ms. Botha to go through the response to the submissions, which was quite long, or whether you want us to attend addressing those 7 points that came out of the submissions and the public hearings.
Thank you very much, DM. I think the department can take us through those 7 issues. I know honorable members will recall that, you know, we had quite an in-depth process in terms of oral submissions as well, and members also have all the written submissions, as well as your documentation. Obviously, in our next meeting, we will structure our deliberations more in depth following, you know, some of these issues. Over to you, Deputy Minister.
All right, thanks. So look, the first issue was that the bill is not necessary. We've got existing remedies in our law. And let me deal with that one, and the officials can add if they want to. But that argument is basically, well, that we've got PAPUDA, the Promotion of Equality and Prevention of Unfair Discrimination Act. And that does provide for remedies against hate speech. But those remedies are basically civil, to take the matter to the Equality Court. So the person who's aggrieved to go to the Equality Court. And it's not criminal. Our view and the reason for the bill was that there's a duty on the state to ensure that hate speech doesn't occur. It can't be left up to the individual to have to themselves go to an equality court, and they may need assistance, they may not be able to get it. So it would be the duty of the state, as with other crimes. I mean, other crimes you can bring civil actions as well, but the duty of the state to prosecute where it believes a crime has occurred. The second issue that's raised is we have in our law a common law crime of crimen injuria. As the name implies, it's an old Roman Dutch crime. As with other common law crimes, it gets developed by the courts. But the issue is that we felt it was better to have a statutory crime. So let's take, for example, as another example, rape used to be a common law crime. When we passed the Sexual Offences Act, we made it a statutory crime and set out the elements that needed to be proven for a rape. One of the issues before was, could there only be, without maybe offending people or going into too much detail, but with rape, that it was only penetration of the vagina and not other forms of penetration, and that definition has changed in the Sexual Offences Act. So it is up to Parliament to change common law crimes where it feels it's appropriate to do so. So that, for example, provides that new, previously male rape was not a rape in terms of a common law crime, but it is now in terms of the Sexual Offences Act. So our view was that we should have a statutory crime on hate speech, not rely, which is basically in keeping with the issues that are particularly prevalent and relevant at the moment. So that's the other reason for a statutory crime on hate speech. There's some confusion. If you look at a textbook definition of crimen injuria, it specifies that it must be against a particular person. Whereas the issue of if you use it against a group of people, not an individual, so you say something racist about a particular race group or particular religious group, that that may not be criminal injuria, and the courts haven't ruled on that. So that's the response on the issue of, is this bill necessary? Yes, we feel it is. We feel the state has a duty to prosecute hate speech, and that criminal injuria is not sufficient. We also feel the bill actually provides greater protection to certain categories of people, religious people, researchers, journalists, artists, than criminal injuria does. So I don't know, Chair, through you, if Mr. du Preez or Ms. Botha want to add anything on that.
DM, we're in your hands, so you can just run with the process.
Yeah, okay, so Mr. Botha, Ms. Botha, sorry, Mr. du Preez, sorry, I've just changed your genders. Mr. du Preez, Ms. Botha, do you have any things you want to add on the first point?
Good afternoon, Madam Chair, members of the committee, my Deputy Minister.
Mr. du Preez, I'm sorry to disappoint you, but it's still morning.
I thought there's a time difference between Cape Town and Pretoria, but in any event, I suppose they're more progressive than us. I just wanted to say, thank you. You may refer to me as they, Mr. Minister.
No, we won't get
on.
onto that. And,
Okay.
and yeah.
Okay. No, Madam Chair, I think, yeah, I don't want to add too much more because I think the deputy, yeah, explained it very eloquently. Where I would like to latch on to what the deputy has said, and this is very technical at this stage, but we will explain it to the committee when we go clause by clause, is to say that there's a lot of criticism that certain terms are not defined. But if you look at the if you look at the common law offense of criminal injuria, and you look at Section 16 of the Constitution and Section 9 of the Constitution, and specifically Papuda, terms like hatred is not defined. And we have received a lot of comments on that with respect to this bill, that those terms should be defined. And we feel that they should carry their ordinary dictionary meaning. That's all I would have wanted to add at this stage. Thank you, Madam.
Thanks, Mr. du Preez. If there's nothing from Ms. Botha, maybe if the second point then is the relationship between the provisions on hate speech and the Film and Publications Act, and Mr. du Preez or Ms. Botha, if you can respond on that one.
Thank you, Minister. Madam Chair, with your permission, there's two concerns with regard or that were raised by the Films and Publications Board. When we get the opportunity to quickly run through the highlights of our summary, we will explain them to you. But in essence, it means at this stage that the existing law, as approved by Parliament, with regard to the Films and Publications Act, hate speech is or was created as an offence, but it is limited to the internet, the social media, etc. And also with regard to the sentencing, the argument by the department is that, number one, the ambit of the crimes created in terms of this bill will be wider than that of what is contained in the Films and Publications Act or the Amended Principal Act, as well as the sentencing provisions dealing with being convicted of contravention of the Films and Publications Act. And in short, Madam Chair, it amounts to the fact that the department's argument at this stage is that it's up to a prosecutor in each and every case to decide whether a prosecution will be instituted in terms of the Films and Publications Act, or then the eventual Prevention and Combating of Hate Crimes and Hate Speech Bill or Act, which we feel would be in the majority of the cases. I may just mention that those amendments to the Films and Publications Act were only implemented, if I remember correctly, during 1 March or 1 April last year. So I don't think, well, we haven't got any statistics of any prosecutions that have taken place. Thank you, Madam Chair.
Chair, then the third point was that the bill be split to leave out the hate speech provisions. Now, obviously, if one takes the bill as a whole, there's a lot of, well, in the National Assembly, the bill was supported by all parties, with the exception of the Democratic Alliance, the Freedom Front Plus, the ACDP, and Al Jama. And so it's particularly, I think, directed at well, generally there was wide support across party lines for the bill. So each parties like the EFF, the Inkatha Freedom Party, the UDM, I think, PAC, all supported the bill. Obviously, the provisions that are the most contentious are the hate speech provisions. Basically, people concerned that if their members or supporters say racist things, that they will be prosecuted. Obviously, the bill applies to everybody, not particular race groups. But you know, there is a lot of racial hatred being expressed that should be dealt with by an act of parliament. Then there's also particular, I think, concern around what things you can say that are not positive about people of different sexual orientation, gender identity, and again, particularly from certain religious sectors, very much not all. There are religious groupings that are very much in favor of the bill, but that's a concern for some. But this bill was introduced in 2018. It's one of the oldest bills in Parliament currently. We had to wait for the Kwelane judgment, because that judgment, or the issues before the court in Kwelane, had a key impact on this bill. And that judgment came in 2021, which ruled that PAPUDA wasn't unconstitutional to include homophobia as a prohibited ground for hate speech. So we believe the bill is necessary to be passed as a whole. Let me also just say in that I'm a representative of a political party, the ruling party, the African National Congress. We are undergoing a review of our 2019 election manifesto. And one of the things in that manifesto was that this bill would be passed. So it is something that's been quite thought through, but we, as I said, believe it is necessary for the bill to be passed as a whole. There does need to be protection to members of the public against hate speech. Again, I don't know if Mr. du Preez or Ms. Botha want to add anything. They are obviously not political, they're officials. So I'm speaking as a politician, as a member of Parliament and Deputy Minister of Justice.
Thank you, Madam
So, Mr.
Chair.
du Preez or Ms. Botha, anything? Okay.
Thank you, Madam Chair. We do not have anything to add. Thank you. Maybe just to say that from a bureaucratic point of view, it is also a concern that this bill was in Parliament for such a long time, but we simply had to wait for the Kwilani judgment. But thank you, Madam Chair.
Chair, thanks. The next point then is that the bill is not in line with international conventions. And can Mr. du Preez or Ms. Botha respond on that one?
Madam Chair, from my side, and I'm going to ask Ms. Botha to also add some perspective on this. I think this is also something that we will be able to address the committee more extensively on when the committee goes through the bill clause by clause. But in essence, Madam Chair, that criticism of the bill not being in line with international conventions mainly relate to the preamble. Now, a preamble is always a very tricky thing in a bill because, and this is one of the examples where we've got a bill where the preamble is actually nearly longer than the bill itself. So what I would like to say in short at this stage is that the essential elements start with what our Constitution says. And then we also refer to the most important international conventions or convention which applies to hate crimes. So the department's response at this stage, Madam Chair, and it was also the department's response in the Portfolio Committee, because we received similar criticism there, was to say that we are satisfied that the preamble highlights the essential elements that gives give the background to the bill itself. A preamble is merely personally, I don't like preambles, but we do think that our preamble is sufficient to cover the ground for our bill. I don't know whether Ms. Botha would like to add anything, Madam Chair.
Thank you, Chair. I would like to add onto what Mr. du Preez and my DM has said. And like Mr. du Preez said, this is addressed extensively in our Annex C, which is an additional research note which we have put together in response to and in addition to our summary of responses and in response to the concerns raised in the public hearings. But I think it's important to note that from the research that the department has conducted on this issue around whether the bill is in line with international conventions, it's important to note that the international conventions speak both to the rights of free expression and the rights to equality and dignity. And I think it's important to note that these international conventions speak to both rights, and there are further international conventions which speak to rights of non-discrimination and rights to or the critical point of preventing sort of hate elements. I think it's important, and we'll go through that in more detail when we go through Annex C. But it's important to note that there is even in international law a balancing of these rights. Thanks, Chair.
Thanks very much. Maybe just to say that we are a signatory as South Africa of a number of treaties. I think the pertinent ones in this regard are the Convention for Political Rights. I can't remember its full title, and the Convention for the Elimination of Racial Discrimination. And we have to provide reports to the treaty committees for those treaties as a committee established for each treaty, and we get reviewed as a country. We also get reviewed by the Human Rights Council, as we were recently in a universal periodic review. But coming out of those reviews has been one of the recommendations has been for South Africa to pass legislation on hate crimes and hate speech. So I know this is something, Mr. Mikalakis, that your colleague, Mr. Horn, in the National Assembly has raised, but respectfully, we don't think he's correct. We think, in fact, it's the opposite, that we are compelled to pass legislation on hate crimes and hate speech in terms of our international obligations, and that would be witnessed by the reports from the Human Rights Council or the treaty bodies. Thanks. Chair, then the fifth one is the definition of in the bills circuitous and ill-defined and don't define hate, harm, and hatred. And if Mr. du Preez and Ms. Botha could respond on that one.
Madam Chair, you know me as a person I don't.
Mr. du Preez, you've broken up or you've gone. Are you muted?
I think it's gone. Yeah.
Dictionary meaning. If you want to add or subtract as...
Mr. du Preez, sorry, you got cut off. So can you start from the beginning?
My apologies, Madam Chair. I don't know whether Ms. Botha would like to add anything at this stage, but I'm not going to be long-winded about this. If the legislature wants to add to or subtract from the ordinary dictionary meaning of words or terms, the legislature is free to do that, but we as a department are not concerned that those definitions are what has been said. You will see that in our summary there was a proposal for certain terms to be defined, and it becomes just a task of impossibility. Some of those terms should just carry their ordinary dictionary meanings. Thank you, Chair.
Thank you, Chair. If I might just add that this also is another point that we raised and covered in our Annex C, but just to highlight sort of a snapshot summary of that. The terms hate, harm, and hatred are nebulous. And not only are they difficult to define, they are very much defined in terms of the context of each country, where there is hate crimes and hate speech legislation, where those are criminal offenses. So flowing from that, it's very much tied to sort of socio-historical understanding of what those terms are and what they mean in the context of a country and in context of society and historical considerations. Thanks, Chair.
Okay, I thought you'd give more detail. Is that sufficient to members, Chair? Do you feel, or do you want more detail?
DM, I think members will obviously engage after this presentation if they want additional areas. Yeah, some of saying some more detail already on the chat, so perhaps yeah. Well, I guess.
Yeah, Mr. Mikalakis is asking for more detail. Can Mr. du Preez and Ms. Botha, can you not? I thought you'd give more detail on this particular one rather than just saying the dictionary definition is enough. Maybe you should go through some of the points in Annex C.
Thank you, Madam Chair. That is exactly what I would have wanted to propose is after we've gone through the general discussion, Ms. Botha would be able to lead us through the Annexure C. The Annexure C actually is self-explanatory, and I suppose if one would have read it, there wouldn't have been a request for some more detail. Thank you, Chair.
Would it not be useful to do that now? I mean, just the issues on the vagueness. Sorry, Chair?
No, please. I mean, I think if you can deal with Annexure C now to some extent will also assist the discussion. I thought we're going to try and be more holistic in terms of these 7 areas. But maybe just clarify, DM, so that I'm also clear in my mind about how you intend presenting. My understanding was that you would look at these broader 7 areas, but you would try and be holistic in terms of speaking to the issues. But anyway, but if you feel that you want us to go through a broad perspective on these issues and then go into certain details, I'm not sure whether it's going to assist, but I think the flow at the moment, perhaps it would be better, like, you know, maybe just to try and exhaust what you want to say about each and every area, the better. DM, over to you.
Yeah, thanks, Chair. Ms. Botha, are you in a position, just not the whole of Annexure C, but just to give more detail, because this has been a point that has worried. I think the issues, your Annexure C deals with international conventions, which I would have thought members can read, but just on this point, I thought you could, on the point of the definitions being ill-defined, circuitous, can you not just give a little bit more detail, please?
Sure. Thank you, Chair. Thanks, DM. If I can just share my screen and we can go to Annexure C. Is everyone able to see what is on my screen? Okay.
Yes, we can. Please continue.
Thank you. So we in Annexure C refer to Annexures A, B, and C, but I'm just going to skip straight to, if I may, just the executive summary on part 1. And the department's conducted fairly extensive research in this area, and what's clear from this is that there is no universally accepted definition of any of these words or concepts, that is hate, harm, or hatred, but there are general features which are broad and they're common to both hate crimes and hate speech offences, and that's based on the academic underpinnings of these offences. And so part 1 of this note is broken down into discussing academic text on this issue. And then we zoom in on Germany, Canada, and Uganda in terms of what they prescribe in their legislation to point to practical examples of this disparity. And from the academic text, it's clear that hate, which is a common concept in both hate crimes and hate speech, is largely undefined, and it appears to be driven by the context of that particular country's history. And what emerges from the academic literature is that there are common features of the meanings of the terms of hate and hatred, and there are commonalities in the grounds that are selected from protection across countries. And what also emerges from the literature is that harm is quite a nebulous concept, but it can clearly be felt and experienced by victims of hate incidents. Yeah, like I said, we discuss 3 countries, Germany, Canada, and Uganda, to illustrate this disparity between these definitions. And like I say, there doesn't appear to be any uniformity of meanings of hate, harm, or hatred across any of those countries' legislation. And their legislation appears to be informed by its own historical context in how they frame the offences. And you can see that particularly in the German legislation, which is covered in great detail. And these countries create these offences, these hate offences, through their primary criminal legislation and in separate criminal legislation. That's also, for example, seen in the German context. And it's clear from a study of these countries that legislation differs in detail, as in their meanings and the scope of the offences, and they range in penalties. If I can just go down to just a few areas, we can see from the first excerpt, which is taken from Schwepp, What is a Hate Crime, that on hate crime and hate, although the term hate crime is used across jurisdictions, disciplines, and contexts, there's no uniform understanding of the term. And that is also true that there is no accepted definition at an international level as to what constitutes a hate crime from organizations like the UN, the COE, or the EU. And not only that, but there is no agreed conceptualization of the term across jurisdictions. On harm and hate, this speaks particularly to what harm is, and that the impact of hate crime can go far beyond physical, financial, or personal. Hate crime reaches into the community to create fear, hostility, and suspicion. And this harks back to what the DM was saying at the beginning on point 1, as to the fact that there are offences which already exist. The point of hate offence legislation is that it is symbolic, that it is a strong message that the state sends out that hate offences are not tolerable. And part of why they're not tolerable is because of the harm that is experienced by victims often of a hate offence. That excerpt speaks specifically to that. Here is the hate crime legislation has a symbolic purpose. That hate crime is nested in a web of everyday practices that are used to marginalize and disempower targeted communities. In one sense, as this excerpt says, it's perhaps unwise to have a definition of hate crime which is acceptable to all, because historical, legal, cultural, and geographic influences will all influence local or regional definitions of hate crime. This speaks more to these other excerpts speak more to online attacks and abuse and harm which is experienced by victims of hate offences. Sorry, Chair, I'm just trying to move very quickly through each of these to give a high level understanding and more depth. This excerpt, for example, says there is yet no universal definition of hate speech, although it's been enshrined in different international instruments. The EU defines hate speech as public incitement to violence with hatred on the basis of certain characteristics, including race, color, religion, descent, and national or ethnic origin. The EU provides some non-binding definitions of hate speech, for example, the one by the COE, and the European Commission Against Racism and Intolerance also provides a non-binding recommendation. And I'll just end with this quote from the last excerpt, that hate speech is an equivocal term denoting a family of meanings. It isn't just a term with contested meanings, but rather it carries a multiplicity of different meanings. Because the expression is what is typically referred to as an essentially contested term, the hunt for an equivocal or universal definition is futile. Thanks, Chair. I hope that's enough detail, but I would be happy to speak to it further if that isn't enough detail.
Thanks, Ms. Werter. Chair, I think then should we just do the other 2 points, and then the members can indicate where they've got questions. But the second last one is then the provisions of the bill are unconstitutional and not in line with Section 16 of the Constitution. If I can just start with that one. Section 16 of the Constitution is freedom of expression, and it sets out that everyone has the right to freedom of expression, which specifically includes freedom of the press and other media, freedom to receive and impart information or ideas, freedom of artistic creativity, and academic freedom and freedom of scientific research. But then they go on to say in 16.2 that this does not extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that's based on race, ethnicity, gender, or religion, and constitutes incitement to cause harm. So the argument from some people is that the bill should be limited to just those terms, race, ethnicity, gender, or religion, and it must constitute incitement to cause harm. But that is what is not protected as free speech. The issue would be in terms of the Bill of Rights, there's a limitation clause. What's happening here is a balancing of rights, the balancing of the right to free speech with the right to equality and to dignity in particular. And what PAPUDA, Promotion of Equality and Prevention of Unfair Discrimination Act, has a prohibition under Section 10 of hate speech, which says that no person may publish, propagate, advocate, communicate words based on any more of the prohibited grounds against any person that could be reasonably be construed to demonstrate a clear intention to A, be hurtful, B, be harmful, or to incite harm, and C, to propagate or promote hatred. And what the Constitutional Court in Kwelane said is, okay, that clause as far as it, or section as far as I've read it, is unconstitutional. Hurtful should be removed. And then harmful or incite harm and promote or propagate hatred should be read conjunctively. So you've got to prove that what was said is harmful or incites harm and promotes or propagates hatred. So it could be, just reading it, it could be harmful and promotes hatred or propagates hatred. And that could become then hate speech on the prohibited grounds. So our view after Kwelane is that clause section 10 of PAPUDA is now constitutional. We've used or relied on section 10. We did have it as disjunctive reading, but now the National Assembly put in an and between the harmful or incite harm and promote or propagate hatred. So we feel very clearly it is constitutional. And as Kwelane did, I mean, Kwelane was about homophobia, and the court had said that is Parliament, it was entitled in PAPUDA to make things that were homophobic, if they are harmful or incite harm and promote or propagate hatred, it was entitled to make that hate speech. We've then added in the grounds other aspects, albinism, for example, because people with albinism are particularly vulnerable. And if somebody is inciting attacks on people because they have albinism, that's a problem. We need to prevent that. The issue of immigrants and migrants, rather, they are vulnerable people in terms of attacks on them. So one can be critical of immigrants or whatever and raise the problems, but you can't say things that are harmful or incite harm against them and promote or propagate hatred against them, because that can result in people being attacked and killed. So, Chair, from my side, we feel quite strongly that after Kwelane, this is not unconstitutional. Let me just also say that there have been some submissions that harm should be limited to physical harm. And that's particularly come from some of the religious groupings. But just to point out that the Constitution, where it refers to incitement to cause harm, it doesn't limit harm to physical harm. So why should this bill be narrower than the Constitution as far as harm is concerned? Maybe just while I'm on the floor, in terms of the so-called higher bar for religious proselytizing, artistic creativity, etc. While I'm just dealing with this clause, for everybody else, the requirement is you can't communicate things that are harmful or incite harm and promote or propagate hatred aimed at a particular group on the prohibited grounds. That's what's in PAPUDA. What we've put for academics, for artistic, is a higher bar. And that is following then section 16.2, that it can't constitute incitement to cause harm. So my understanding of the issue is that for most people, you can say, if you say harmful things about other people, other groups of people that promote hatred, you could be liable for hate speech. However, if you are proselytizing, preaching, you can say things about gays and lesbians that they might find harmful, and they might feel that it propagates hatred. But what is the limitation for that is you cannot, what you've said cannot constitute incitement to cause harm. So you can't say that gays and lesbians in church, that gays and lesbians must be harmed. You can say that you know, I don't know why you want to say the things, but if it's your belief, you can say that gays and lesbians are going to hell if they practice same sex. You can say that. But if you then start saying that gays and lesbians must be harmed, that's when, from a proselytizing point of view, it would become hate speech. But let me then hand over to Mr. du Preez and Ms. Botha if they've got anything to add on this one.
Thank you, Madam Chair. I don't want to add anything at this stage. I think the Deputy took the words from my mouth. Maybe just on the last point, just to add to what the Deputy has said, we have to take into consideration that this bill not only protects, for example, free speech within the bounds of Section 36 of the Constitution, but it also protects the dignity of persons on the receiving end of that speech. Thank you, Chair.
Ms. Botha, anything?
Thanks, Chair. Thanks, DM. I just wanted to add in something quite small, and it's that even Kwelane itself recognized that free expression is a right which can be limited, and even though it is fundamental to our democratic society, it is not a paramount value, and that's its section, or rather paragraph 94 of Kwelane. Thanks, Chair.
Okay, thank you. Then, Chair, the last point, which was a sort of more specific one, is that the maximum sentence for hate speech is excessive. And the maximum sentence for hate speech is in the bill approved by the National Assembly is 8 years. I think on the introduced version, the maximum, I think I speak under correction, was 5 years, wasn't it, Mr. du Preez or Ms. Botha?
Madam Chair, it was 3 years for the first offender and then 5 years.
Yeah. So 3 years for first offence, 5 years for second offence. The Portfolio Committee then wanted it changed to 5 years, to 8 years. Part of the difficulty of the legislative process with two houses is that when you deal with the first house, it's the bill approved by Cabinet. When you're dealing with the second house, as we're dealing with now, it is the bill approved by the National Assembly. So in a sense, they should come and motivate on why they put that in. But let me just sort of provide some of the grounds that basically we shouldn't distinguish between first and second offences. It makes it complicated. It should be rather one maximum sentence. And remember, it is a maximum sentence, not a minimum sentence. So you can still sentence somebody to pay a fine or perform certain services, things like that. But I think the issue was, if you have, for example, somebody inciting violence against another group of people, which results in those people or people in that group being attacked and in fact killed, and you don't have enough evidence to actually link what was said to the actual crime, but you can prove it was hate speech, you may want a heavier penalty. But from the department side, we are not married to the 8 years. That would be something for the select committee to deal with in whatever way it wants to deal with it. But remember, as this is a national competency bill, you, as the NCOP, don't amend it. You make recommendations to the National Assembly, which can then be accepted or rejected. And if the National Assembly rejects your amendments, that's it. It doesn't go to mediation like a Section 76 bill. So, Chair, those were the 7 issues. Those were the 7 issues. I don't know then where you want to go. There's then a lot of documentation that's been submitted. There's the response to the submissions, and then there's the 3 annexures that have been referred to. So I don't know if you want the officials to summarize that or whatever. Let me just say that from the hearings and the submissions, there are a few amendments that the department would want to propose to you. But we haven't brought that document at this point, but a few of the things are valid. We also, or could be tightened. We also have had a request from the NPA to make a few amendments as well. So we were thinking that in the next meeting, the department would bring a version of the bill with track changes with those proposed amendments. But if you want more detailed discussion, we can do that. Thanks, Chair.
Thank you very much, DM, for the input in those broader 7 areas. Just in terms of what was presented, honourable members, I think if you have any question, especially in terms of if you want more information on certain aspects, and also if you feel that the broader 7 areas did not necessarily cover some of the issues, you're welcome to raise that. DM, just in terms of the other 2 annexures, perhaps I'll allow members to maybe ask questions, but it would be good also just to give us a high-level summary for those 2 as well. I think in our next meeting, obviously, we will then have a more structured deliberation on the bill. It's currently 12:30. I think we don't have that much time. I was hoping to push till 1:30, but I know some members are going to be traveling to Parliament as we do have a plenary at 2. All right, let me, from a show of hands, honourable members, if they are okay. Honourable Mikolakis, you may go ahead. And any other honourable member, if you wish to raise anything or comment, you can also please raise your hand. Honourable Mikolakis.
Thank you, Chairperson. I am going to, based on what you just said, going to summarize some of the issues and questions that I have, and and perhaps go into a bit more detail when we have more time for the structured session. But I think what I am going to put forward is hopefully going to give the department a clear idea of the issues that I still have. Perhaps I should not take the political bait of some of the comments that were made initially by the Deputy Minister, but I do want to say one thing, and that is that we have come quite a long way over the last 9 years. And I think that if there is any doubt that the reasons for my objections, at least, are for any other sinister reason than trying to put the best possible bill forward, then clearly after 9 years, we don't know each other well enough. My motivation for these questions is it is our job to make sure that proper legislation is put forward, and especially if we're dealing with criminal law. And I think that in that sense, we all on this committee, and hopefully the department as well, shares that objective. We can only, if we agree on that, move forward and find each other on this bill. Having said that, Chairperson, I would like to start initially with the sanction itself. Now, I know that the 8 years sanction was proposed by the National Assembly. The reading that I did last night with regards to the feedback of the department to all the submissions made it seem in the feedback from the department that they are satisfied with the 8-year proposal. I would like to inquire from the department if that is indeed the case, or whether they still stand with their initial proposal of 3 years. The reason why I'm asking this is that I am, on my side, much more in agreement with the department itself with the 3 years than I am with the National Assembly. We heard in the submissions that the NA's amendment to 8 years was largely based on emotional considerations of selected members on that portfolio committee, and I would indicate to the department, as they already know full well, that you can't legislate criminal law based on emotions of members of parliament. So my question to the department is, are they still, from the department's side, of the opinion that their initial submission of 3 years makes more sense? Or do they want to align themselves more with the amendment of the National Assembly that changed their initial opinion? Again, I would much rather align myself, and I hope the committee will do it as well, with the department's initial submission of 3 years. And if that means that the NCOP has to differ from the National Assembly, well, that's the whole purpose of having a bicameral parliament. Then, with regards to the second one, Chairperson, just shortly with regards to the definitions, there's a lot to be said with regards to these definitions. But the main note that I made was the comments from, I think in particular, Ms. Botha, and that was that hate, harm, and hatred are definitions that cannot be defined. It has to be defined in the context of South Africa. And then Mr. du Preez also said that these aren't defined in Papuda and so forth, and they need to follow the dictionary definition. My question and my submission to the department is that, unlike with regards to Papuda, we are actually dealing here with criminal law. And we all know that in criminal law, the definition is quite important because it sets out the elements of the crime. My question to the department is, if the department itself cannot define these core elements of the crime, the department, in other words, is not able to say clearly in the legislation what these crimes are. And if the department can't define these crimes, how on earth is it reasonable to then expect of the general public, who aren't lawyers, to be able to know what the crime is before they are sentenced and sent to jail for committing something which they, in all probability, could not have known what the crime is? And it's easy to say, well, everyone knows what hate is. as was said at a previous occasion by the Deputy Minister. But with respect, Deputy Minister, if you can't define it, then clearly there are different views with regards to what exactly constitutes all of these concepts. And it would make for very bad criminal law if we aren't able to clearly define and set out to the public exactly what it is that they will be doing wrong and sent to jail for. So my submission, and I would like the department's comment on this, is that unlike with regards to PEPUDA and so forth, we are actually dealing with criminal law here, and the bar is a lot higher with regards to definitions than it is in civil matters. Just again on the definition, I would like to ask if it would, there are submissions with regards to comedy, satire, and so forth that are implied, the department said, in the definitions or in the exclusion of Section 4. And with regards to Section 4, I would just like to know whether it would do so much harm to make what is implied, such as comedy, satire, so forth, to make that rather explicit instead of implicit. I don't think it would take away from the legislation to make what is implicit explicit, specifically with regards to things like comedy and satire. And then my big problem, or one of the big problems with Section 4, is that it does protect certain elements in society, science, arts, religion, but it does not protect those who actually share that information. It only protects, as far as I see it, the person initiating it. So I do think that for Section 4 to do what it is intended to do, we need to make sure that it does not only protect the comedian, but those, for example, who share the comedy clip, or not only the initiating scientist, but also those who share the information forth from that. So that is a big gap that I still see in Section 4 itself. Chairperson, there are a few other smaller aspects with regards to whether the bill is actually aligned with the Quilane judgment and other aspects, such as whether actually the balance with regards to specifically the Rabat Plan and the international law is struck in this legislation. But safe to say for now, for my initial big concerns, the definitions, the sanction, and those specific aspects of Section 4 are the big concerns that I do think we need to try and find each other on those three aspects. Thank you very much, Chair.
Thank you very much, Honorable Mikalakis. Honorable Didobu. Any other honorable member, please raise your hand as well. Honorable Didobu.
Thank you very much, Honorable Chair. I am outside, and I beg that I must not switch on my camera. I'm in the by-elections, and I'm struggling here. The situation is not okay. Having said that, Honorable Chair, let me welcome the submission from the department, especially on the 7 issues that it has highlighted as key issues that need our careful interrogation and inspection. I think this is very, very good. We will do exactly that. And every time, in my view, when these issues are raised, they trigger some issues that needs to be attended to. Secondly, Chair, I want to say all of us as South Africans must agree that the issue of hate speech and hate crime is at the heart of who we are as a country. And we must do everything within our power to combat those. And this piece of legislation really needs our support, needs us to ensure that it is finalized and thereafter implemented. that is signified in the way that many people in their thousands have made submissions. They've written to us. They have done oral submissions to us. They want their voices to be heard. And we as legislators, we cannot fail them to ensure that we pertinently and carefully consider all the submissions. And the 7 issues that have been highlighted do point to the fact that we are doing exactly that. And that is why it is important, so important, that we must pay attention to those issues. Now, having sketched that brief background, Honorable Chair, I want to underscore certain issues. And one is the issue of definitions. I want to really implore on all of us, including the department, to really ensure that we are careful about the definitions. And as we are aware, there's been some concerns about the fact that some definitions are overly broad, while some of them are vague, and they may be inconsistent with the principles of the rule of law. I beg that we must really carefully look at those definitions and ensure that whatever that we define as hate speech or as hate crime is properly defined, is properly explained, and it doesn't create problems. I'm raising this particular issue because, as we all know, some of the advocates for free speech argue that if we don't do that, we might end up doing what is called self-censorship, which will be quite problematic in terms of how we're moving forward. Because whilst we say hate speech, hate crime, we must make sure that at the end of the day, we do not self-censor people from expressing their views in a democratic and unacceptable way. And my view is that we must really look at that and pay the necessary attention. The second issue that I want to bring forward as well is that whatever that we do must not limit the constitutional right of South Africans to freedom of expression. As I pointed out, they must really look at that. I don't know, somehow, Honorable Chair, I really want a conversation as we work towards the closure of this particular bill, that we must really revisit this maximum sentence of 8 years. Yes, Honorable Deputy Minister, 8 years, it is not minimum, it is maximum sentence that can be meted. And obviously, the nature, the context, the background, and the way in which all of this hate speech and hate crime happens and is perpetuated differ and years. There might be a point in us looking at that and really concerned that 8 years might be a very harsh, especially when we are a country with this history and background that we have. And my view is that once this bill has been promulgated, the process is finalized, we as South Africans, formal and informal way, we must embark on vigorous campaigns of education to educate our nation, to educate our people around these particular things. Because some of the people might perpetuate these crimes, hate crime and hate speech, unknowingly, unwittingly, and without real intentions. And my view is that education must be at the heart of what we do, must be the pinnacle of how we conscientize and make our people across the board aware that this that you perpetuate or you may perpetuate is a hate crime or is a hate speech that is prohibited in terms of the law. My view is that education must be at the center to ensure that we succeed in that eventuality. Another issue that I want to raise, Honorable Chair, I don't agree with anyone who says we must separate these bills. And there has been that concern, and I want to put it forward. I think the process is advanced. South Africans are looking at us as parliamentarians to finalize this particular process. Therefore, we can separate hate speech from hate crime as a bill and have two pieces of legislation. We are at this point, and my respective view is that whatever issues that are obtained that are there, we must resolve them. South Africans want this particular piece of legislation finalized and implemented because it is at the heart of their lives, at who they are, and it must be finalized as such. Now, Chair, the last point, there's been some concerns about I don't want to call them the duplication, but some similarities and some applicabilities in respect of this bill and the Film and Publication Act that is already in place. And as the Deputy Minister indicated, it will be upon the discretion of a prosecutor to decide whether you are prosecuted under the Film and Publication Act if you committed specific crimes that are relevant. And I must emphasize that particular point. And for me, we need to look at that so that there must be congruence and similarities, and that there must not be unnecessary conflict at the end of the day in respect of this bill, as well as the Film and Publication Act. I will pause there, Honorable Chair, but having said that, welcome the 7 points, key points, which were raised by the department. I think this is what we must, with a microscopic eye, look at these issues, ensure that whatever conflict, whatever deviations, whatever problems that are there are accordingly ameliorated. With that, I wanted to make that contribution, Honorable Chair. Thank you very much.
Thank you very much, Honorable Dodovu. Honorable Dlamini.
Thank you, Chair. I think I've been broadly covered by the members who are on the floor. So mine is just to emphasize that there is a grave discomfort when there's no clear definition, and we are referred to dictionary definitions of what the word hate means, which means that we are open to any form of interpretation of what that definition is. And so, as Honorable Dodovu has correctly said, that from the history that we come from, depending on which side of history you fall under, there is ways of wanting to manipulate what was and what happened in the past, and what does it mean for us now in terms of how it was legalized also. And I think the interpretation of that also can be easily manipulated into hate speech. And I want us to give a bit of a comfort, or maybe if the Deputy Minister can go back as to, because I saw when they were trying to explain in terms of other laws from Uganda and Germany and so forth, maybe go back as to revise as to when it comes to the interpretation of what hate is, what are the parameters that are going to be used in its definition, so that we don't feel like the bill might be used as a way to gag what we define is the truth of our people. Thank you, Chair.
Thank you very much, Honorable Dlamini. Honorable Motsamai.
Thank you, Chairperson. I think the Honorable Dodovu and the Honorable Mbali, they took everything that I was going to ask. I don't want to waste time. I'm covered.
Okay, no, thank you very much for that, Honorable Motsamai. I think I'm also pretty much covered on the issues that members have raised. I don't see any other hand that is being raised, so I assume members are also pretty much covered by the issues that were raised. Deputy Minister, let me then perhaps, I know we are going to have more in-depth discussions around the issues, especially the clauses of the bill as we move forward. But there are some pertinent issues that were raised. If you wish to address some of them, some are comments as well as some are more deliberations as well on certain matters in relation to the bill. But if you would want to clarify some matters around what has been raised by members, please, over to yourself.
Thanks, Chair, and if the officials could add, but I think I must start, and thank you for all the comments. And maybe just to echo Honourable Dodovu, this bill is not meant to be the solution to racism, sexism, homophobia, religious phobia, whatever. It is one part. And so a lot more needs to be done for social cohesion, but we feel there does need to be a law criminalizing the more overt expressions. So I just want to echo what he said in those regards, or that regard. Let me just say to the Honourable Mikalakis, no, I do respect you, Honourable Mikalakis. I also don't think you're a fish, so I wasn't trying to bait you. But on your question of wanting the department, and remember I'm ministry, their department, and so let me protect them. I don't think it's appropriate. The department brings the bill from Cabinet. Whatever it feels about the bill, that is what Cabinet approved. But when it comes to Parliament, I don't think it's appropriate for the department to play off the two houses and say, yeah, the NA National Assembly wanted this, but we don't like it. NCOP, will you change it? So, Chair, I don't think Honourable Mikalakis' question is fair. I think the issue of the sentence is up to the committee. I don't think the department can take the sentence issue any further. So I would appeal that the officials are not asked whether they stand by what was in the bill before, because it's then going to be using the department to play off again between the NA and the NCOP. And remember, there are often differences, and correctly so, between the two houses. Sometimes Section 76 bills, there can't be agreement, they have to go to mediation. The other point I wanted to just make, and I'm sure the officials will add more on it, I mean, harm is defined, hate is not. But do we not know what hate is? The idea of this is not, and it would be limiting free speech. And that is why the prosecution has to be instituted by the Director of Public Prosecutions, the provincial head. They can delegate it, but it's under them. There's not going to be people rushing around wanting to charge people. It's, I think, going to be relatively clear-cut what is hateful, harmful, or basically what the requirements of the bill are. And there is a relativity aspect of where does this come from. So let's take the K word, which everybody accepts should not be used in society. But in Olive Schreiner's Story of an African Farm, it is used, because in that historical context, that's what was used at that time. Olive Schreiner was a progressive person in terms of both racial and gender equality. And I think she didn't know any better. But you can't say, no, we must change A Story of an African Farm because of that word. I think if it's prescribed, that context needs to be explained. Similarly, there will be issues of where the courts have to decide and interpret and set the law. There was an Equality Court case under the Papuda Act where an artist had done an artistic display in an exhibition with the words, and I guess I better spell it rather than say it, but F, let's say star, CK, white people. And somebody went to the Equality Court to say, no, this is hate speech. And the Equality Court, it was at the level of the High Court, had found, no, this was artistic expression because of that context. And incidentally, it was a white person who'd done that display. So I think the problem is that the department can say, but for me, it's clear what's hateful. The broader edges may be a little bit fuzzy, But then I don't think the intention is to go prosecuting people and things. It's we know what people should or shouldn't say, and I wish people could be nicer to each other. But there will be grey areas. The courts would have to interpret those areas. I just wanted to make those points, Chair. Maybe if and just with the freedom of expression, it's a balance between freedom of expression and the right to dignity. I think the Americans have absolute freedom of expression, but we don't in South Africa, and that is why we can restrict people from hate speech. Already under Papuda, there was an issue with the K word when Minister Bodan was at SARS, and one official used the word and got fired, and then appealed his firing. And the court, it went to the Constitutional Court, I think it said, no, the use of this word is very bad, and therefore you remain fired. You're not going back. But anyway, let me hand it over to the officials just to add. Thanks, Chair.
Thank you, Madam Chair.
Add or contradict.
Yes, thank you, Madam Chair. And I appreciate my Deputy Minister covering for the department with regard to sentences, as he rightly pointed out, and it's always easy to follow the Deputy Minister because he's putting everything on the table. But the department goes with a proposal to Cabinet, and I'm referring to sentencing now, and it was accepted and it was taken to Parliament, but you are the legislature, and if we stick to the 3-5 split, then one could think of the example of Momberg, who was sentenced to 5 years, which is in any event the maximum. I'm very tempted at this stage to say, or maybe to recommend to the committee, don't put in a maximum sentence and leave it to the discretion of the courts. And we might be surprised in future that there are examples of such egregious offences being committed that it will go beyond 8 years. That's all that I want to say. And then when it comes to satire or the like, just to add to the deputy's example, if you read some of Wilbur Smith's books, then you will find that he is actually there's actually child pornography in those books, and it is prohibited, but it doesn't mean that those books are banned in South Africa. Madam Chair, maybe I should leave it at that, but I think the crux of the matter is, and the deputy just reminded the members of the committee that it's not only about freedom of expression, but it's also about the dignity of others. And it's if you look at the provisions in our bill, you will see that it's a high hurdle to pass before you will be convicted of hate speech, because you have to comply, or the state will have to prove 2 sets of requirements before successfully convicting someone of hate speech. With that, I will stop there. Thank you, Chair.
Okay, thank you very much. DM, are you covered?
I'm covered, Chair. I don't know if Ms. Botha wants to add anything.
Thanks, Chair. Thanks, Chair. Just on the sanction point, the department did provide Annexure C2, which is a comparative analysis of hate speech and related offences in 10 different countries. And that is also inclusive of Germany, Canada, and Uganda. And the reason we provided that annexure is just to give the committee an understanding broadly of those different jurisdictions and the ranges in penalties that exist across the world when it comes to this hate offense legislation. Thanks, Chair.
Okay, thank you very much.
That's it from our side. But maybe also, you know, if you call someone a cockroach, well, a cockroach is not a very nice, it's not a very popular insect. But if you call somebody a cockroach, a lot of it is context. You're not being very nice. But in the context of Rwanda, and if it's sort of people from the Rwandan community who may be in South Africa, and to call each other cockroaches has a different meaning, because in terms of the genocide, that word was used to incite people against the Tutsis. So it does depend on that's where the definitions become, or to have a list of words that are hateful and cause harm or promote hatred. It's more difficult. It's the context, who's saying it, in what context are they saying it, that has to be looked at. And just to the two honourable members from the EFF, you know, the issue of whether kill the Boer, kill the farmer is hate speech is still something with the courts. The High Court in Johannesburg, I think it was, had said, no, it's not. But then I think there's been an appeal by Solidarity or AfriForum or whoever on it. So a lot of it is context related. So even the F***CK white people, the context was looked at. Yeah, so, but thanks, Chair.
Thank you very much, DM and your team for those responses. I note that we are also probably we have 3 minutes before 1. Yeah, we are running out of time. But let me thank you for that. And I think, honourable members, this does give us some kind of broad background around the issues that were raised, and I think members have made quite positive, you know, contributions into this matters. And yeah, I think we've had quite a fruitful input this morning, or this morning/afternoon. I think our members, I think given these presentations and the explanations of some of the issues, members, you can further familiarize yourself with the documentation that was also provided to us. And I know the detailed responses by the department and all the public comments are also in the possession of members. But members, I think we'll then take our deliberations further next week, Wednesday, when we meet again. Let me thank the department, Minister, and your team. We will then deal also with any other proposals that you might have on the bill in the next meeting. But obviously, as a committee, we would want to deliberate further on all of these matters that we also discussed today. With that said, thank you, DM, your team. Thank you, honourable members. And as well as I'm sure the parliamentary legal advisors also on this platform. Let me declare this meeting closed, honourable members, because I know some of you need to get to the house as well for the 2 o'clock meeting. But thank you very much. We'll meet again next week, Wednesday. We'll inform the department and members accordingly in terms of the date and time. Thank you very much.
Thanks, Chair.
Thank you, Chair.